to all of our colleagues from the Leaders That Influence channel on WhatsApp, all you entrepreneurs in insurance. We are coming to you today to talk about trade secrets, something overlooked by a lot of startup founders and a lot of scale-up companies, actually. So I'm with Mary Guzman, the founder of Crown Jewel Insurance. You've all met her. She's very active in our channel and in our community. And Mary's going to talk about this fantastic product that she created, authored, first in the world. It's a first-party trade secret insurance policy that everyone can benefit from. Every company, every size, startups, scale-ups, long-lasting companies. So Mary, with that, I'll turn it over to have you just kick off and level set everyone on what a trade secret is and why they could benefit from the insurance.
Awesome. Thank you, Kate. I appreciate it. We're going to go fairly quickly through this and hope that people will individually reach out to us with questions or comments or ways that we can help them. So one of the things that we wanted to do first and foremost was just sort of level set on what is a trade secret. We created this slide deck really for companies that qualify for R&D tax credits, because many of the innovation assets that are created using R&D funds, CapEx and payroll combined, that allow for R&D tax credits to be taken would qualify as trade secrets. Not all of them, but it's a good sort of kickoff point when you're talking to your clients or you're thinking about your own organization. If you qualified for R&D tax credits, it's very likely that you've got some trade secrets. Does all confidential company information qualify as a trade secret? Well, there's a legal standard that's been around for over a century now. Trade secret law, unlike a lot of other law, is largely based on case law as opposed to legislation. And so there's something called the 6-factor litmus test that we use and that courts use and have used for a long time now to determine whether or not something truly qualifies as a trade secret. If a confidential information asset or something that you've created, a know-how, some technical process that you've learned over years of trial and error or software code, or we're going to give you several examples of different kinds of trade secrets. If that information is not protected as a trade secret, then it's not a trade secret. And I think that's one of the most fundamental things that organizations are missing when they try to assert their trade secret rights, which the only way to do that, again, is to bring a case against another company who allegedly has taken your trade secrets.
So just to back up 1 second, Mary, when we think about intellectual property in the United States, there's generally 4 categories that most people are familiar with. Patents that get registered for protection, copyright registered for protection, trademark generally registered for protection. The last one of the 4 is called a trade secret. It is the only intellectual property right that is granted, for lack of a better word, by meeting the 6-factor litmus test.
But it's not registered. But it's not a registered asset, to your point.
Yeah.
Yep.
Yeah.
So there is no sort of quasi-legislative or regulatory body that gives you carte blanche use, exclusive rights to that asset over a certain period of time, which is what happens when you register the other 3 types of intellectual property. Therefore, because the asset is kept secret and never registered, i.e. never publicly disclosed, unlike patents, for example, which become public the minute they're published, those assets have to be protected properly in order for you to somewhat guarantee that you're going to win in litigation when you try to enforce your rights. And it's certainly never a guarantee, although what we're doing is guaranteeing that what you think is a trade secret and we think is a trade secret is in fact a trade secret. That's a huge benefit to the insurance, which we'll talk about in a minute. So the 6 factors of the 6-factor litmus test are the extent to which the knowledge is known outside the company or business, the extent to which it's known within the company. This is something that a lot of folks don't think about, which is that if you have information, know-how, something that you've developed, whether it's software code or customer lists, that is available to every single person in the company, it's unlikely that you're going to be successful in showing that that was a trade secret, period. That may not be true for startups, for very small companies where there are only a handful of people who have access to the information because you're all working so collaboratively as a team at the very beginning of the formation of a company. But if you've got 50 or 100 employees and everybody has access to whatever you think is a trade secret, it's probably not a trade secret. The third thing is that you have to put quote unquote reasonable measures around that information or know-how or developed asset in order to keep it a secret. What are reasonable measures? That's a lot of the discussion that comes up during litigation because there is no set definition. It all depends on circumstance, size, complexity, all of those kinds of things. But we have some significant thoughts on what reasonable measures look like because that goes into our underwriting process. The information has to be valuable. So just because you created something that's really cool and innovative doesn't mean that it provides value to your organization and would also be valuable to a competitor. That's the fourth part of a litmus test. The next part is the effort that you spent to develop the asset. If you develop something, on a sticky note, and it took you 5 minutes, it's a great idea, maybe, but it's probably not a trade secret. Trade secrets generally take a lot of time, energy, and effort to develop. And then the last thing is how difficult other people would have, what the difficulty would look like if someone tried to reverse engineer the trade secret without inside knowledge. If it's something that can easily be reverse engineered once it becomes out in the public domain or once it's in flight or in use, as we like to say, then it should be patented or protected under other registrable intellectual property right. Because if you can easily reverse engineer something, like you can take a cell phone, take the component parts apart and see exactly how it's made and put together, the phone itself and the component parts that make up that phone probably should be patented, but the know-how behind that, the software code and the technology that makes the camera much better than the previous camera that can't be discernible by taking the phone apart, those are all trade secrets. That's sort of the difference.
So one of the primary things that you just talked about, Mary, to give people context. So one, we're educating about what a trade secret looks like inside of a company because there is no statute that tells us. It's all case law, and we know the case law is all fact laden. But why does it matter to us, and how does the insurance apply? Trade secrets, once stolen, are then generally litigated. So during the course of the life of the trade secret, it's sitting around on the floor. It's in the closet. It's in someone's head. It's walking around. It may be walking out the door. Someone may be bringing trade secrets into the company. And it's not until there's a theft and a misappropriation and there's financial damage do people then try to enforce the right through litigation. What you're trying to do is educate people that they have this asset right now, and that during the underwriting process, we will determine if a trade secret would meet the standard during litigation. If we certify or verify that, in fact, we believe it would meet the standard, then we could list it on a schedule, right? On a policy schedule, the value, and insure it. And that's why we talk about trade secrets in the first instance, is to get ahead of letting these assets just lay around to be stolen during the course of their life and then litigating it upon their death. We're trying to reverse that with this insurance.
Right, exactly. Because if you wait until the assets walk out the door, you've got 3 critical engineers that have been part of your development team since day one. They've been working on a particular project for 4 years. They walk out the door to go to a competitor just before your IPO or right after a merger or some critical time, doesn't really matter when it is. They take that knowledge and know-how with them. If you cannot prove that that asset or those assets that went out the door with those people were trade secrets, the only leg you have to stand on in terms of litigation is contractual for violating non-competes or non-disclosure agreements potentially, but you're not going to be successful in bringing the very, very robust damages claims that arise out of trade secret misappropriation. It's a completely different animal. And so to Kate's point, what we're trying to do is tell people, make sure you've got a trade secret by putting reasonable measures around it before it's too late.
So
So
Mary,
in terms of
just real quick, in terms of a reasonable measure, in the instance of engineers that maybe started with a company walking out the door because there's a strategy disagreement or there's a, a new infusion in capital and they don't, they're not keen on how the board's driving sales, for example. What are some of the reasonable measures that you can think about when it comes, of course, it's all the way across the company, whether it's cyber protection, where the data lives on a database, those are all reasonable, who has access to them. In the HR, what we typically think about in HR, what are some reasonable measures in the HR space?
Yeah, so when we think about reasonable measures, clearly cyber is where everybody goes initially because most of these assets are at the end of the day culled down and stored somewhere as data assets. And so access control, encryption, need to know basis, all of those kinds of things that you would normally think of around privacy should be applied here, except for maybe even on steroids, number one. That's easy to do if you have a CISO or a chief technology officer who's already in lockstep with what needs to happen in privacy. They just need to know that these assets are also just as critical so they can do the right thing in protecting them. The non-technology piece of this is hiring, firing, training, non-competes, and non-disclosures, primarily those 5 things, which are all really legal and HR functions that need to be in place. For example, if you're not doing exit interviews when people walk out the door and you're not taking the devices of people and doing, forensic scans to make sure that they're not removing information they shouldn't be taking, getting them to sign something, re-acknowledging that they know that what they were working on was a trade secret and that the company owns it. Again, it's going to be very difficult to be able to prove the trade secrecy of that asset in litigation. These are easy steps to take if you just know what to do. And so we're here to spend some time and energy on that. Equally, when you're onboarding an employee, get them to sign something acknowledging that they're not bringing any trade secrets or any proprietary know-how from prior competitors. That is getting a lot of companies into a lot of trouble right now. There are 3 different Y Combinator companies that are all involved in litigation right now, involving bringing former employees from another company to their job who allegedly took trade secrets. In one case, Palantir is alleging that a company started their entire business based on what they took from Palantir. They're going to spend hundreds of millions of dollars and potentially, sadly, go bankrupt during litigation. So this is critically important. This is just a list of what are some things that could be trade secrets that I think might surprise some people. They can be almost anything as long as they meet the other criteria that we talked about. So they need to be developed by you, valuable, have reasonable measures around them, but it can be go-to-market strategies, M&A strategies and targets, marketing segments, pricing models, algorithms, databases, process developed over years, manufacturing floor layouts, all of these things. One thing that I wanted to mention in that today's environment is really challenging for a lot of companies is that the output of generative AI specifically, perhaps some of the input as well, but definitely the output of generative AI is being challenged around patent eligibility right now in courts because it's being deemed in many cases that that output is not generated by a human. And patent and copyright law both require that the person who developed the innovation or that the innovation be developed by a person. So that means that generative AI output that may only be generated because you had the very specific input and data from gathering information from your customers, for example, to put into the ML model to spit out the output, it still is not going to be an asset or an asset that you own unless you A, use a private model to protect that information, and B, protect it as a trade secret. So generative AI is creating a lot of noise in the legal space right now, and it just needs to be paid a lot of attention to. The last thing is just to think about, for every single company, every single penny that you're spending in R&D, and this is why we talk about R&D tax credits, every single thing that's being developed in R&D could be a trade secret, should be treated as a trade secret until you decide that it's no longer valuable, it's not working, or you decide to patent it or use some other protection methodology. But later stage R&D things are almost always trade secrets until the day they're patented and that patent is approved. Then that know-how becomes public, the design, drawing, code, whatever it is. But up until that time, every single patent in the world is a trade secret. It's not insured anywhere. What does not qualify as a trade secret? This is a fairly exhaustive list, but it sort of goes to say that it's everything that falls outside of that 6-factor test. It's generally known in the industry. It's already obsolete. It's not valuable to you or wouldn't particularly be valuable to a competitor. A lot of times things are made publicly available without non-disclosure agreements for example, in tech transfer offices of colleges and universities when they're jointly working on something with a company. Anybody who's publishing a detailed paper about the research they're doing makes it obsolete or makes it too known in the public for a lot of that information to remain a trade secret, something a lot of organizations don't think about. And proper non-disclosure agreements. Most companies have NDAs with third parties with whom they're providing or to whom they're providing corporate confidential information, but they may not be nearly robust enough to address the very specific nature of trade secret assets. And there are several different provisions we look for as best practices that we're happy to talk about.
Yeah, to your point, Mary, what we see is that when companies have these agreements that are overreaching and say something like everything's a trade secret, everything's company confidential, everything in a third party agreement's a trade secret, that it has no value. It's too exhaustive. It's not specific enough. It's not focused on the asset that, again, you're trying to keep secret and protected. So to Mary's point, there are provisions that we look for that are a little bit tighter in all of the agreements.
Mm-hmm. So what we have done in order to get A, capacity, but B, also help clients with due diligence outside of just insurance, we do standalone consulting, helping companies sort of get insurance and litigation ready, as we like to say. But we developed this would look like an ERM, enterprise risk management process, to any of you with risk management training, which most of you are going to have, except for that it's very specific to intangible, valuable corporate assets. So first and foremost, you should be identifying and tracking the assets that you believe could qualify as trade secrets from day one. As soon as somebody comes up with a good idea, or you're already working on a process and it's starting to gain traction and something that you don't want your competitors to know about because it's giving you a competitive advantage on how quickly you deliver your product or how fast you can load your trucks or how much less waste is on your manufacturing floor than somebody else. As soon as something starts to give you a competitive advantage, it's a trade secret. Okay, so we want you to keep identifying and tracking those. That becomes immutable evidence that we will need, or that you will need, if and when you ever have to go and enforce your rights in court. Many jurisdictions around the US do not even allow for discovery to begin in a trade secret misappropriation claim if you cannot demonstrate with evidence what the it is. What is the trade secret you're alleging somebody else took? You can't go to them and say, we don't know, but they took terabytes of data. It does not work anymore. Okay. The second thing is, first you identify, next you value. We're not necessarily saying that you hire a third-party valuation firm right here, although that's what we would do to ensure the asset if you want to cover the potential future value of the asset, but at least have some sense of how much money you've spent developing the asset, the capital expenditure, the payroll, the time and energy associated with developing something, so that that sets a floor. So the cost to create something includes negative know-how, which is another sort of term of art in trade secret law. That means we have figured out a lot of things about what works by figuring out what doesn't work. Example, WD-40. WD-37 was getting really close in terms of a lubricant for your car engine, in terms of what the company wanted it to do. If the engineers that were working on WD-30 through 37 walked out the door at WD-37 and went to work for a competitor, you could see how they could easily tell that competitor, just start at WD-37, we already know what doesn't work. That gives that other company unjust enrichment legally, which is a form of damages in trade secret law. So if you want to capture that, that's a good way to think about, what's our negative know-how worth? How much time, energy, and effort did we spend developing what we know today? That sets a good floor for valuation. It's not the ceiling, it's the floor. And we can bring in other experts to look at the potential future value of the asset, which can either be revenue generating or it can be savings generating by giving you efficiencies in what you're doing.
So Mary, just pardon the interruption, but the value is important because that's identifying the asset, knowing the value of the asset is what we need to schedule it on the policy, like you would a piece of property, right?
Mm-hmm.
You know the address of the property, you get an appraisal, and that appraised value is basically what's being insured. Same thing for a trade secret, right?
Exactly. And a lot of people don't think that you can value a trade secret. Yes, you absolutely can.
Yeah.
It is doable. It's been done for years and years. It's just usually done lumped into the rest of an IP portfolio of a company, as opposed to being called out as individually valuable assets, which is a shame, because I think a lot of companies are dramatically undervaluing themselves by not valuing trade secrets that they have right on the gold dust on the manufacturing floor, that they're not sweeping up into gold bars, as my friend David Pardue likes to say. The next thing is protect. We talked about this already. There's physical protection, which we didn't really mention, but that seems relatively obvious, that you need to have access controls to certain server rooms and manufacturing floor, and limit cameras that can be brought in, and have badges, and ideally, retinal scans and all those kinds of things if you're regarding something super secret. And then we talked about the contractual, technical, and other policies around HR, legal, and information security. Those are going to be critical to proving that you use reasonable measures, which again is not a defined term. So the further ahead you are in being able to prove that you have at least met sort of minimum standards, if there are some in your industry, like in DoD and others, where you have to qualify to be a contractor by showing that you're in compliance with certain cybersecurity protocols, you want to beat those, okay, when you're guarding trade secrets. The next is to insure. So identify, value, protect, insure. That's where our Innovation Guard insurance comes in, which is a first-party insurance policy that schedules these as assets, because they are actually assets. They're not just expenses that you've thrown away in R&D. Those are actual assets that can drive the value of the company, drive the valuation for fundraising, drive the valuation for loans. It's critical that you have some sense of what these assets are worth and can demonstrate that in your pitch deck and in other discussions you're having with third parties.
Mary, if I could interrupt again, I think the big difference here where we see light bulbs go on for people is this product is a first party product. When I first started talking to Mary about the product, the analogy for me would be a warranty. You buy a refrigerator, something happens to it, you file a first party claim. This is not intended to be a liability policy like most of your other IP, people say IP insurance, but they generally mean patent protection or patent litigation funding, which is very different than this product. It's a first party product.
Yep, it's really crime insurance for your most valuable asset. If it gets stolen, we pay. First, we try to get the asset back, and we do a damn good job, or we will do a damn good job if that happens to you, because we've got all the evidence we need already lock, stock, and barrel, supported in a very secure way. We can, with the push of a button, demonstrate what the it was, what the reasonable measures were, who had access to it, were there non-competes in place, did somebody have an exit interview? Those things typically take months or even years of backwards discovery and cost literally millions of dollars if you don't have your ducks in a row. So we're saving people insane amounts of time, energy, and stress by putting this process in place. And then the last thing, of course, is to recover and enforce. So if we insure, again, the first thing we're going to try to do is use our legal and forensics teams to get the asset back and cure the impairment, meaning make sure that there aren't damages, which could be unjust enrichment of the third party or actual loss of revenue, by enforcing our rights. If we're not successful, then we pay the fair market value of the asset, which we pre-agreed at the beginning of the policy period. Again, that can either be just what you've spent so far, if that's all you want to buy, or it can include the future value of the asset. Once we pay you the fair market value, then we more than likely, if we've got all the evidence we think we need, and we know who the bad guy is and they have a deep pocket, that's a question mark, but we will more than likely subrogate, which means that we become a litigation funder in a sense, but without you having to pay for it, because we're just subrogating to get our own money back. If we win in litigation, one of the beautiful things about the Defend Trade Secrets Act is if you can show that the third party egregiously and obnoxiously stole your trade secret willingly and knowingly, you're more than likely to be eligible for not only punitive damages, but your own defense expenses recovered. So there actually have been some very significant claims recently, one where the punitive damages and the legal fees were as big as the compensatory. Just happened last week. So these damages are huge, some of them in the hundreds of millions of dollars. But if we're successful in litigating and getting our money back, then the first thing we do is repay ourselves. And then whatever is left over, a significant portion of that goes back to the insured, goes back to the insured. Let me say that again. I don't know of any other insurance in the world where subrogation pays you back over and above the limit that you bought the insurance for. It's a huge win-win. So you could potentially get $50 million on a $20 million limit policy that you paid for by following the process that we're doing. Another huge upside for us.
I think we have a graphic. I was going to say, I thought we had a graphic on how what you just said plays out.
Yep. So I'm not necessarily going to walk through this whole thing, but because you can look at it at your leisure. If you're reviewing this, just stop on this and study it for a minute. But it is clearly shows that you have an asset that you spent $10 million on, the future value of it, and all the negative know-how that came out of how you've developed it have made it worth $20 million. We potentially pay the $20 million when that asset goes missing. If we're not successful in putting the genie back in the bottle, we subrogate, we potentially win 60, which is 3x, which is eligible for, could happen under the Defend Trade Secrets Act. That it means that the insurer ends up paying the insured $30 million in excess of claims and expense payments. So it's, again, a significant win-win for companies who are questioning whether or not this is valuable.
And beyond that, to Mary's point, it's not just about the insurance. It's also we are starting to see companies sell at an amount that's almost inexplicable by the CFOs and the deals. And it's because there's a trade secret that has more value than what's being carried on the books, because trade
significantly
secrets,
more value.
Yeah, because trade secrets are not carried on the books. So keep it in mind when you're thinking about valuations, you're thinking about selling, you're thinking about maximizing the value of your company. The trade secrets.
And if you're an investor, I'm sorry, but if you're an investor, if you're a VC or private equity, I know there are a few of those in the group as well.
Yeah.
These are off balance sheet assets, but they are assets nonetheless. And so if you've already got a bunch of portfolio companies in your fund, you should look seriously at those and consider strongly both insuring them, putting this risk mitigation strategy in place, and valuing them, which I said in reverse. You'd obviously get all three if you insured them, but it will bring significant value to the valuation of every single company in your portfolio if they have any money that they've spent in R&D, which today is really why companies are buying other companies. You're not buying them because they own a bunch of airplanes. You're buying them because they're innovating something really cool, different, awesome, something that's going to save the world. That's what we want to do. We want to help companies who are saving the world.
So probably a good stopping point, Mary, because this gets more into, how can you leverage your R&D tax credit reports. But one thing that folks can do is absolutely look you up on LinkedIn, reach out to us at Crown Jewel, www.crownjewelinsurance.com, and ask for help, for guidance, for consulting. We have a Trade Secret 101 package where we basically get you insurance ready, or at minimum help you institute protocols that would rise to the level of reasonable measures.
Yeah, and the Trade Secret 101 packet is very inexpensive. We're charging $5,500 for it, and we'll take a company who has basically no trade secret policy and procedure and no training in place from 0 to 70, not 100, but 70. Yeah. If you want to get all the way to 100, we have Trade Secret 201 and Trade Secret 301, which includes some additional features where we add the valuation piece formally by an outside third party, and where we use some technology to help you find your trade secrets and document the existence of such in the first place using a really cool software tool that we're white labeling. We'd love to talk more about any and all of those, so please reach out to us if you want to talk further.
Fantastic. Thanks, Mary.
Thank you.